Mr. Coleman, can I just go back to one thing that you raised yesterday? It's the jurisdictional.
Yes.
Was the point taken for Mr. Justice Foxton that the argument that is being advanced in this court, and which was the alternative argument advanced to him, was not open because it wasn't within the question of law?
I would say yes, although it may not have been expressed in jurisdictional terms. We've got our skeleton argument in the core bundle, which I'd like to refer you to address that point. It's, in fact, it's paragraph, it's tab 20 of the supplemental. It's paragraph 5, page 264. I invite your lordships to read what we said. I accept I didn't make the point as forcefully as perhaps I have in this court, but you see the concluding sentence: the appeal on the point of law must therefore fail.
That treats it as an issue that,
yes,
that had to be decided, but which you were contending should be decided in your client's favour.
Yes. I mean, whether or not I submit I did take it in substance. If that's not right, then it remains a point of jurisdiction.
But if you did take it, then it's not a point that the judge dealt with. Is that what you're saying? I mean, the judge did deal at some length with the jurisdictional point in relation to the contractual entitlement argument.
Yes, yes.
And he gave permission in relation to that.
Yes.
And that's not the subject matter of permission to appeal.
No.
So if it was taken and he's to be taken of having dealt with it under that rubric, you face a difficulty in not having permission to appeal on the point. If it was taken and he failed to deal with it, then obviously you don't have that difficulty. But
in fairness to the judge, it may be said that at most we took it obliquely in paragraph 5, and he hasn't squarely addressed it. But I say nonetheless it's a point of jurisdiction.
I understand that point. Thank you.
Lord, when we adjourned, Lord and ladies, when we adjourned yesterday, I was developing the first headline submission, which was that Brown Rudnick's claim for damages in relation to the success fee is a claim in respect of a civil liability within the meaning of the insurance clause. I'd completed my submissions in relation to the natural and ordinary meaning of the insurance clause and the policy terms as a whole. I then turned to the commercial and regulatory context and common sense, which we say supports our construction of the insuring clause, which we deal with at paragraphs 43 to 47 of our skeleton argument. Since the court is considering standard policy terms in which all solicitors in Northern Ireland are required to be insured, the terms fall to be interpreted in the context of the sorts of liabilities and losses that may typically be incurred by a solicitor in the course of practice, and for which the profession and the law society in Northern Ireland would expect solicitors to be covered in the interest not only of solicitors, but also of the public as well. And this approach appears to be common ground. See paragraph 42 of the insurer's skeleton argument. the breadth of the cover that the compulsory terms provide in respect of civil liability that may arise in the course of practice reflects their purpose of protecting primarily the public, but of course solicitors as well. And we've cited the observations of Lord Brightman in Swain and the Law Society concerning the insurance scheme in place in England and Wales under Section 37 of the Solicitors Act 1974. You saw the relevant passage yesterday when you went to the Mortgage Corporation case. The judgment was just at the Vice-Chancellor in that case. But I would, if I may, like to go back to it, and perhaps it's best to go to the authority itself, which is at tab 11. Of the bundle. This was a claim brought by ordinary originating summons, not by judicial review, by two solicitors against the Law Society for a declaration that they were entitled, or the profession was entitled, to any brokerage commission accruing to the society for the benefit of the profession. And they suggested that the brokerage commission, when the society put in place the insurance arrangement, should be paid back to the solicitors who were affected or subject to the scheme. And the House of Lords held no, because the Law Society was exercising public functions, public powers, and therefore not subject to the private law fiduciary duty to account for commission. So that was the context in which these observations of Lord Brightman were made. And if you could go, please, to page 190 of the bundle pagination. We've got from letter B to E, the passage which I think you've read already from the judgment of Mr. Justice Weinlott. But I would just like to emphasise the point made by Lord Brightman at letter C, that the scheme is not only for the protection of the premium-paying solicitor against financial consequences of his own mistakes, the mistakes of his partners and the mistakes of his staff, but also, far more importantly, to secure the solicitor is financially able to compensate. Because, of course, if the purpose was simply to protect the solicitors, you wouldn't need a compulsory scheme. Solicitors can be left to their own devices for that purpose. And a similar point is made at letter D. So the entire rationale for these terms, or at least the principal rationale, is to protect the public. Now, those comments, of course, were made in the context of the English regulatory scheme, but I think it's common ground that essentially the same considerations apply in relation to the Northern Irish scheme, which it has an equivalent statutory basis. In my opening or introductory submissions, I've already given some examples that we say help to demonstrate that solicitors reasonably require insurance in respect of civil liability that they may incur in respect of fees, and that the protection of clients, the public interest, requires that solicitors be insured for such claims. And we've given further examples in paragraph 44 of our skeleton argument, if the court would go back to that, please. It's at page 146 of the court bundle. In subparagraph A, we give the example of a client paying a substantial fee to the firm on account of costs. The partner absconds with the money. The client sues the innocent partners on the basis that they are liable to the partner's wrong. They're all jointly and severally liable, and they could all be required to, in effect, reconstitute the trust fund. The client money is held on trust. In effect, all liable to return the money to the client. And we say a solicitor would reasonably want and expect insurance in this situation. So would the public interest. As we understand the insurer's case, there would be no cover because the claim would relate to fees received by the firm.
And or might be restitutionary.
And or might be restitutionary. But if it's restitutionary, it's difficult to see there'd be a change of, if it's restitutionary in the broad sense, there would be no change of defence position. The firm, all the partners are trustees of the money. And if the money's gone, they would be required to return it to the client or reconstitute the fund.
It's the client's money.
It's the client's money. And subparagraph B, we give the example of a solicitor acting for the client in a claim which is struck out. The client has paid the fees which were contractually due. What remains of the fee after payment of tax has been expended on the solicitor's business. The client brings a claim alleging that as a result of the negligent advice, he pursued hopeless litigation, and he claims as damages the amount of the fees that he would not have incurred had he been properly advised. Now, in fairness to the insurers, I perhaps should correct what we say in paragraph 44C, because I think we do say there that, as we understood it then, insurers say again no cover. But listening to my learned friend yesterday, and having regard to the concession recorded in paragraph 107 of the judgment made by Mr. Hubble, King's Counsel below, as I understand the insurer's position, that they would accept that there is coverage in this example relating to negligent advice or conduct causing wasted fees. Well, we would agree with that, but we would add that if there's coverage here, in this scenario, it can only be on the basis that a liability to pay damages in respect of fees paid to the firm is indeed a civil liability within Insurance Clause 1. And a true loss. And as we say in subparagraph D, the problems to which the acceptance of the insurer's case would give rise may be further illustrated by the facts of our case, subject to some adjustment. Suppose that Mr. Coulter had absconded with the fee. The posited scenario is actually not very far removed from the facts, because Mr. Coulter did attempt to divert £6 million of the fee, see paragraph 18 of the Arbitration Award, but he was thwarted by his partners. On the insurer's case, the innocent partners would face an uninsured loss. And again, we say that cannot be right. Liability arising from the theft of money by a partner or by an employee of the firm, whether it is the proceeds of fees or client or other client money, or indeed other money, is a core risk against which the solicitor requires insurance and which the public interests require that the solicitor be insured. Now, as I say we say in subparagraph, or rather paragraph 46 over the page, of course the complicating feature in this case is that the fee was not stolen. But the fact that part of the fee is held by the firm, subject to the undertakings of the National Crime Agency and to the Law Society, cannot affect the meaning of civil liability. We say that any benefit that the respondents may receive from the fee is not relevant to the scope of cover. It's relevant only to the debate that we are having in the next part of my submissions in relation to loss. Now, in paragraphs 48 to 58 of our skeleton argument, we respond to 4 general arguments advanced by the insurers as to why they say that Brown Rudnick's damages claim as regards the fee is not covered. I'm going to return to those, if I may, after I've developed the second headline submission, to which I now turn. And the second headline submission, to remind the court, is that the liability in respect of Brown Rudnick's damages claim in relation to the success fee, if established, would proximately cause a loss so as to engage the insurer's obligation to indemnify. And that is essentially for the reasons that the judge gave. And we have developed this submission at paragraphs 59 to 67 of our skeleton argument, which in essence reflects the reasons of the courts below. I would like to make 5 points in support of this submission. The first is that the starting point is that, subject to the terms of the policy, the insurers are liable for all losses proximately caused by the insured peril. And at paragraph 59, we've cited McGillivray on insurance, which we've got, if we could go to it, please, at tab 40, volume 2 of the bundles. Page 1141. Where, under the heading General Rule, it is a fundamental rule of insurance law that the insurer is only liable for the losses proximately caused by the peril covered by the policy. And then, in the next paragraph, second line, the insurer is liable if such a cause is within the risk covered by the policy and is not liable if it's within the perils accepted. And then, as we say in paragraph 60 of our skeleton, the respondent's right to an indemnity in respect of the loss proximately caused by the civil liability, if any, will accrue if and when any liability to Brown-Rudnick in respect of the fee is ascertained by judgment or agreement. In other words, there is no accrued cause of action as regards at least the liability. And we have cited at paragraph 60 the relevant extract from McGillivray on insurance. If you could turn forward in the bundle, please, a couple of pages to 1145.
I doubt this is going to be in dispute, is it?
It's not in dispute.
This is Post Office Union. It's classic.
Basic.
It's
stuff.
basic, but yes, it's the building block though for the answer to the approach to loss. What then follows from that is that any liability, if any liability is established in respect of the success fee element of the damages claim, then the amount of each respondent's liability will provide the basic measure of the loss. Now, of course, I say basic measure because there may have to be adjustments to reflect how any judgment debt is actually discharged as between the partners. But the amount of the judgment debt, if it was, say, a one-partner firm, would give you the basic measure. And if you have a multi-partner firm, then the basic measure will be the amount they each contribute to the judgment debt. But it's helpful, I submit, to identify as the starting point the basic measure of loss. And at paragraph 60, we cite 2 cases for this proposition. The first is the judgment of Mr. Justice Devlin in Westwake and Price and Ching, which we do have in the authorities bundle at tab 10, but it's sufficient for present purposes if we go to the citation of the case in the judgment below. Paragraph 101, full bundle, page 103. Paragraph, yes, 101, page 103, where Mr. Justice Foxton said that it's well established that a policy of indemnity insurance entitles the insured to recover its actual loss, not more than its actual loss. Generally, there is little difficulty meeting the requirement of a loss and a liability policy, as Mr. Justice Devlin noted in Westwake, when dealing with a claim for damages for negligence and fraud, the assured cannot recover anything under the main indemnity clause or make any claim against the underwriters until they have been found liable and so sustained a loss. If the judgment were given against them for the sum claimed, they would have undoubtedly sustained a loss. And that approach is reflected in an observation made by the judge himself, at paragraph 113. If we turn forward, please, to page 107. Where just before the quotation at the bottom of the page, you have the sentence, "It is the ascertainment of the liability by settlement, judgment, or award which creates the indemnifiable loss in third-party insurance cover." The other case that we cite for the proposition that the amount of the liability gives you the basic measure of loss is the mortgage corporation case, which you saw yesterday, in which the judge dealt with at paragraphs 104 to 106 to 109. I think we agreed on this side of the court that this is perhaps not the easiest case to actually understand the facts of, but one can't really improve upon the summary that the judge himself gave of the case at page 105. If you could go back, please, to page 105 of the bundle, paragraph 104 of the judgment, and perhaps if you could remind yourselves, please, how the judge summarised the facts at the top of 104, which is all one needs for present purposes. Just to the end of 104, please. And if we can take up the authority itself, please, at tab 15 of the bundle 1. You may remember that the arbitrator very much relied upon this authority in his approach to the issue we're debating at paragraph 7 of his partial final award. You'll recall from yesterday that the Solicitor Indemnity Fund argued that under the terms of the insurance scheme, the quantification of the firm's loss caused by the liability must take into account the benefit that the firm had received as a result of its own negligence. Can we please go firstly to page 241 of the bundle, where we have the relevant insuring clause. We can pick it up about 5 lines down into the text of the clause, beginning the words halfway along the line, each member thereof. Each member thereof shall become entitled to be provided with indemnity out of the fund in the manner set out in Rule 7, and to the extent and subject to conditions and exclusions set out in the following paragraph against 1. All loss, including liability for third-party claimants' costs incurred by the practice or any successor practice or any member thereof at any time arising directly from A. Any claims first made or intimated against the practice or any successor practice or any member thereof during the indemnity period in respect of any description of civil liability whatsoever, which may have been incurred in private practice, by the practice, or by a member as a member of such practice. And so it continues. And then turning to page 243 of the bundle, to the argument for the claimant lender. So it's 241 of the bundle. You see at the second hole punch on page 241 that the argument of the claimant lender was that in this case the loss incurred by the firm is the amount of the judgment debt plus the cost of the action. He relied on the passage from Westwake and Ching, which you saw a moment ago. And over the page, there's a citation of the decision of Lord Justice Benning in the Post Office, well-known case of Post Office in Norwich Union, about when the cause of action accrues. And picking it up at E, the judge records that Mr. Driscoll, for the claimant, did not rely on those cases as providing any direct guidance on the construction of the rules, but he did rely on the way in which the test of liability under a claims-only policy was formulated in the passages I've cited. And then there was a citation of the Hayden case, which explains the nature of a claims-made policy with which we're concerned in this case, with which this court will be already familiar. And then across the page at 243, letter C, the judge, having set out a passage from Hayden, said that again, Mr. Driscoll did not rely upon the decision in Hayden as providing any direct guidance on the construction of the rules. He submitted that the terms of the policy in that case in effect made explicit what's less explicitly stated in the terms of the SIF scheme, namely that the liability relates to claims made against the insured. Pausing there, that of course is the same in our case. You'll recall from insuring clause 1, the liability relates to claims made against the insured. So in the instant case, he submitted, the indemnity against, quote, all loss incurred by the practice extends to the claim made by MCL for damages suffered as a result of the firm's negligence, and not to the loss suffered by the firm after taking into account the fact that as a result of the firm's negligence, the consequent loss to MCL, the firm was able to continue to borrow from the bank on the security of the cottage. And then in the next paragraph, we have the argument of the SIF, and perhaps if the court would remind itself of what was said in that paragraph on behalf of the SIF. And then in the next paragraph at F, we have the judge's reasoning, which I submit applies with equal force in our case. I prefer Mr. Driscoll's approach. The indemnity extends to any loss incurred arising directly from any claim against the firm, founded on negligence attributable to the firm. The language points to the amount of a claim for damages established against the firm, not to the ultimate consequence to the firm of its liability under the judgment, after taking into account other transactions entered into by the firm. And then we have an example which I'd invite the court to read. It caused some head scratching below, because it may well be that in the second line over the page, the reference to recover, well, I'll let you read the example first, and then I'll help you with how it seems to us it should be read. we can only make sense of that example if in the second line at the top of page 244, where it says would be unable to recover damages to the firm's negligent failure, that it seems to us be intended to say would be unable to recover against the fund under the Third Parties Rights Against Insurers Act. One reads it that way, it does make sense. And then we have the example which touches, we say, very closely on this case, indeed on Mr. Norris's construction, in the case of almost any transaction giving rise to a liability and negligence, the claim by the client against the fund would be reduced by the benefit to the solicitor of any related fees he was entitled to charge and retain. Now, Mr. Justice Vinelot accepted in that case that one leaves out of account other transactions. My learned friend sought to distinguish that on the basis that it was referring to ancillary transactions. But on any view, the transaction in that case was very closely connected with the alleged negligence. As a result of the negligence, the firm improved its own financial position. And here we say the other transaction, to use the language of Mr. Justice Vinelot, which one does not take into account, is the transaction for the provision of services and the fees earned under it. You have, on the one hand, the misrepresentation, which is the actionable wrong. The benefit under the other transaction that one leaves out of account is the fees paid as remuneration, contractually due for services rendered. That is a reading which appears to have commended itself to the arbitrator below, as I've said. If we turn, please, to paragraph 7, I think we can put that case away. But if we go then to see the reliance that the arbitrator placed in it, you've got that at paragraph 7 of the final award, full bundle. Tab 14, page 141. Sorry, 191. Bottom of page 191. Where he said that there was no basis for stripping out the success fee from the general declaration. Brown Rudnick claims loss from the payment of the fee, and if that is part of their loss, so be it. There is no legal basis for removing that element of the loss, because the claimant has made a gain by receipt of the fee. Support for the claimant's position is afforded by the decision of Mr. Justice Vinelot in the Mortgage Corporation case. Now, as the judge remarked below, the reasoning is brief, but when one looks at the Mortgage Corporation case, it does support, we say, the arbitrator's approach on this point. The second point that I make to support the headline submission, that the liability, if established, would approximately cause a loss, is this. The rationale behind using the amount of the liability established by judgment or agreement as the basic measure of an insured's loss applies just as much to a liability to pay damages in respect of a fee contractually due, but procured by misrepresentation. As it does to a claim for damages and negligence, or any other insured claim within the insuring clause. There is no offending against the indemnity principle, rather it gives effect to it. I think has already been canvassed in argument yesterday and is reflected in the judge's judgment. The firm's provided a service using the firm's resources. The fee may have been expended on the business, and any sum left over retained as a profit. The liability in respect to the fee in misrepresentation is a real loss, falling within the scope of the insured peril. And it's perhaps worth reminding oneself in this context that under a contract for services, the supplier of service is entitled to a fee, even if one hasn't been agreed. That's section 15 of the Supply of Goods and Services Act. We get that from the passage in Chitty, which you've got at tab 44. If we could turn that up, please.
So just give me that reference again.
It's bundle 2, tab 44, my lord.
44.
Yes, tab 44. It's the passage at 4-147 under the heading Incomplete Agreements for Goods and Services may be cured by law. And I invite the court just to read that paragraph, please. And can I remind the court that this is a case where there was always the expectation that the firm would be paid. This isn't a case where services were being provided gratuitously and then there was some late change of arrangement whereby there was a decision to pay after all. One can see that services were always to be provided if one goes to the 2 retainer letters. You can put the bundle away.
Before we do that, I'm not quite sure what you're getting out at this point.
Well, it's simply that on the question of loss, services were provided, and there is a common law right to remuneration for services, quite apart from a contractual right.
Is that what I thought this passage was saying? You do have to have there's a statutory right. It only arises where there's a contract, but where it arises where the contract doesn't fix the fee.
Yes. Well,
so it's not. We aren't dealing here with non-contractual services.
Well, we would say there is a contract insofar as the firm was providing through Mr. Coulter services, and the expectation fee would be paid.
Well, I understand that. I'm just slightly puzzled what you get out of a provision, a statutory provision, which applies to contractual services where the fee is not fixed.
Yes. Well, the point is simply that even prior to the fixing of the fee, which is said to be contaminated by misrepresentation, the fee wasn't contractually fixed until July. Even prior to that, there were services provided in the expectation fee would be paid.
Do you say there was a contract at the moment the services started to be paid? Started to be provided?
Yes, one could infer a contract if services are provided and there's an expectation that payment will be made.
Well, that might well involve a factual investigation that hasn't been undertaken in this case.
Well,
that's certainly not always the case. As if you start providing services in expectation as an implied contract.
No. Well, I don't need the point. The point is that there was a contract.
It's accepted there was a contract.
The fees were paid.
And it's accepted that services were provided.
Indeed, and we say it's fees paid under a contract and not a gain for relevant purposes. On the other hand, not recognising the liability as a loss would leave a substantial gap in cover and has serious financial implications for solicitors. And that was a point which the judge implicitly must have had in mind. And standing back and just looking at the sorts of situations which may arise typically under this sort of contract, typically services by a firm will be provided using the firm's resources, both material and human. Even in the case of one person providing the services, the firm's goodwill, facilities and so on, reputation are being deployed. On the other hand, liability in respect of the fee can be incurred as a result of the conduct of one individual. And so the innocent partners have an obvious interest in insuring against their civil liability in respect of the fee in circumstances where they are exposed to claims in relation to the fee as a result of the conduct for which they are vicariously liable. And even in the case, we're not concerned with the facts of this case, we're concerned with the point of general principle, but even in the case of Mr. Coulter, he was, as the arbitrator found, acting in his capacity as a partner of Tughans, where he had an office and so on. Now, on this point, we do commend the reasoning of the judge. If we could go, please, to his judgment, starting at tab 7 of the core bundle. At page 105. And it's paragraph 107. Which is perhaps the key paragraph in the judgment on the issue of loss. The judge begins by stating that Mr. Hubble, King's Counsel, this is at the bottom of page 105, rightly, in my view, accepted that where a solicitor who's performed work negligently is sued for damages which include wasted fees paid by the client, the solicitor's liability in respect to the wasted fees would ordinarily be capable of constituting the loss for the purposes of the policy. And he said that over the page, that reflects the fact that the solicitor has accrued a contractual right. And in paragraph 108, he addresses the position in relation to conditional fee agreements. And in 109, he says that in short, in each of these scenarios, I'm satisfied that if the solicitor has done what's necessary as a matter of contract to accrue a right to the fee, an award of damages in the amount of the fee payable would ordinarily constitute a loss for purposes of a professional indemnity policy. that is the correct analysis conceptually, as well as being consistent with the public policy of providing a measure of protection to the solicitor's client. You'll be out of pocket whatever the basis on which the solicitor agreed the right to payment, which was identified as a relevant factor in construing the policy of this kind in the mortgage corporation case.
Presumably you say it doesn't matter that the solicitor has accrued that contractual right as a result of a misrepresentation.
No, because the same policy considerations apply, the same legal considerations apply, the fee has been earned, and as a matter of policy, the implications, if there's an exception for misrepresentation, would be very concerning. It could mean, as the judge said in the examples he gave at 135 and 136, if there's a misrepresentation in relation to the expertise of the firm, or in relation to counsel's advice on the merits, that's my example, made by one partner, fraudulent or negligent, because the insurer's case can't distinguish between fraud and negligence, then all the other partners are at risk for an indeterminate period of a claim emerging some years later, seeking to recoup the fee. Exactly the same reasoning applies. And so we do, my lady, Lord Justice Andrews' question takes you then forward straight to 134 to 135. Again, we commend the court the reasoning there.
Sorry, is it 134 or 135?
It's 134 and 135. 134 starting at page, paragraph 134 starting at page 133. Your court will already be familiar with what is said in those key passages right through to 137. But in my submission, my learned friend on behalf of the insurers can't distinguish his case, certainly not on the basis of a point of law of general importance, from the examples given by the judge at paragraph 135 and 136.
The judge expresses these in terms of a claim for damages.
Yes.
Because he's earlier considered whether as a matter of policy language rather than under the indemnity principle, claims for restitution are covered.
Yes.
And concluded not. Is that
He did conclude that they weren't. I'm going to come on to whether that was correct or not. But in my submission, the point about restitution is a red herring in this appeal, because it was not a claim for restitution, and the arbitrator characterised the claim on unchallengeable grounds as one in damages, and that's plainly what it is.
Yes.
So that's what we say about the judge's judgment. We invite you to accept his reasoning. The third point to support the headline submission, that the liability, if established, would cause a loss, is really the one I've already made in response to questions from the court, which is that the approach to indemnification of claims should be the same for negligence-based claims as misrepresentation-based claims. There is no basis on which they can be relevantly distinguished. The commercial and regulatory context supports treating them the same. And this is the point that we make in paragraph 48 of our skeleton argument. Ultimately, yesterday, under the force of analytical questioning from the court, the insurer's case appeared to collapse into a submission that there is no cover if there is a liability in respect to the fee. That such a proposition, if accepted, would open up a very concerning gap, both for solicitors and for the protection of the public. even if it was confined to liability and misrepresentation. But there's no reason, in principle, why it could be confined to liability and misrepresentation. It would have to extend across into any liability in respect to the fee. The fourth point to support the headlines submission that the liability, if established, would approximately cause a loss is the point we make in paragraph 65 of our skeleton, which is that general condition 9D of the policy specifically addresses what shall be deducted from the amount payable under the insurance in the event of dishonest, fraudulent, criminal or malicious acts or omissions by a partner. And it doesn't provide for a deduction of fees. I don't think you've seen this clause yet. It's at Core Bundle 15, page 204. Clause 9, top of page 204. The key provision is 9D for our purposes, but perhaps if the court would please read 9, focusing in particular on the introductory words and subparagraph D. And we say this is a further clear indication that the fees earned by the firm are irrelevant to the application of the indemnity principle under the policy. As I said yesterday, it's common ground that the indemnity principle and its application is shaped by the terms of the policy. And the fifth point I make, which the court will have in mind anyway, it's the point made by Mr. Justice Foxton at paragraph 137. And that is, if we're concerned with a question of general importance in this appeal, as we must be, then the question of whether the liability is covered does not depend upon any assessment one might make as to the size of the fee in relation to the value of the services. And indeed, this court is not in a position to make any such assessment because there are no relevant findings made by the arbitrator. So far as the point of principle is concerned, the correct answer as a matter of principle would be the same, whether the fee be large or small, and whether the services provided in exchange be substantial or slight.
And that's because the value of the services, so far as the client is concerned, are most readily measured by what the clients agreed.
It's the only evidence we've got, what clients agreed in the context of a £1 billion plus transaction. So when thinking about the general point of law, we've got to posit not only the facts of this case, but the facts of a substantial piece of litigation involving tens or hundreds of thousands of hours over several years. where it said that the fees were all procured by misrepresentation. So those are the 5 points. In paragraph 51 of their skeleton argument, the insurers seek to equate this case with that of an insured who holds fees to which they are not entitled as constructive trustee. Of course, there is no equivalence in this case, given the conclusions of the arbitrator and the judge that the fee was due and payable in full title past. And the judge addressed that point, in particular at paragraph 134. And as I understand it, there is no dispute between us as to the basic principles of contract and property in terms of title passing under a contract, which was voidable but hasn't been avoided, and indeed, in this case, has been affirmed. You've seen that Brown Rudnick bring a claim for breach of contract. They rely on it. I now turn to pick up, as I said I would, some general assertions made by the insurers, as we understand it, as to why the fee element, the Brown Rudnick damages claim, is not covered. The only two which I haven't yet addressed are these. Firstly, there is the assertion that since the policy does not cover any liability founded in restitution, it cannot cover a damages claim in respect of the fee, which is in substance, it said, the claim for restitution. That was a point, I think, certainly a point made in paragraphs 52 to 59 of the insurer's skeleton argument, and is still, as I understand it, advanced. That's the first general assertion I'm going to respond to. The second general assertion, and this is paragraphs 43 to 50 of my learned friend skeleton, is that since the policy does not insure unpaid fees, it does not indemnify loss caused by liability arising from fees that were in fact paid. I'm going to take those two general points in turn, if I may, starting firstly with the contention that since the policy does not cover any liability founded in restitution, it cannot cover a damages claim in respect of the fee, which is in substance, it said, a claim in restitution. We have responded to that contention in paragraphs 49 to 51 of our skeleton argument, pages 148 to 150 of the core bundle, and also in paragraph 7 of our reply to the insurer's supplemental skeleton argument, core bundle 16, pages 212 to 213. I make now 4 points in response. I'm going to reverse the points, if I may, in paragraphs 49 and 50, because the point in paragraph 50 is perhaps a dispositive point, and that is this. Both the arbitrator and the court have held that Brown Rudnick's claim is not in substance one for restitution. And that, we say, is not open to a challenge on this appeal, and is in any event correct. Starting, please, with the arbitrator's characterisation of the claim in the partial final award, core bundle 13, please, if we could go to that, page 176. Paragraphs 22 to 23. Where the arbitrator said that this letter of claim and the statement of claim which followed it are of central importance to this dispute. This is liability insurance, and an understanding of the claim is necessary to determine the question of cover. This is not simply a question of formulation, but of the nature and essence of the claim which is made. And then you see at paragraph 23, he found that the nature and essence of the claim was is one for misrepresentation and damages. The arbitrator returned to the point in his final award. If we could go to the next tab, please. Paragraph 8. Page 192. Four lines from the bottom of paragraph 8 at the top of 192. The arbitrator said, I should add that there is no claim for restitution by Brown Rudnick, or any likelihood of one. If such a claim were to be added for tactical reasons, it would plainly be a subsidiary claim and would fall to be treated for the purpose of the insurance in accordance with the principal compensatory claim. I submit that on a point of law raising an issue of general public importance, which is the requirement in section 69(8) for an appeal to this court, it's not open to the respondents, the insurers I should say, to challenge the arbitrator's characterisation of the claim as being in substance one for damages. But insofar as it is, it's fully borne out by the way it's pleaded by Brown Rudnick in the statement of claim. You went to it yesterday and read the summary. Can I just give you what we say are some other paragraphs which you've probably read already? I won't turn them up, but they are paragraphs 54, 55, 55 through to 71, which deals with the various causes of action, including, importantly, contract. And contract's not just there as a make weight. There's a long list of particulars you saw in paragraph 15, it seems, supporting the contractual claim.
I'm wondering, Mr. Coleman, whether you're actually shooting at a target that isn't there, because as far as I can remember, I don't recall Mr. Hubble ever suggesting that the claim was in substance a restitutionary claim. What he was saying to us was that essentially the solicitors weren't entitled to the money and had to give it back, and it didn't matter how you characterised the claim. That's as I understood the way he was putting it. And I see he's nodding.
Yes. Well, if it's common ground that it's not in substance a restitutionary claim, then yes, it's that. But I do rely on the point that it's not a restitutionary claim, because one looks at what does the cover, the insurance clause cover, and what doesn't it? It undoubtedly covers a claim for damages, and this is the claim we're dealing with. And it's in relation to the relationship to restitution, I would also make the point that it could not have been formulated as a claim in rescission because the contract had been affirmed. Quite apart from the potential legal debate as to whether one could rescind in principle a contract where the services have been provided and the contracts have been fully executed. So
there's two separate points. But how was it affirmed by the claims that were made?
Yes. Yes. Well, my learned friend said yesterday that the contract had never formally been rescinded. That was his point. And then it's been affirmed by...
It's clearly been affirmed by the way that the claim has been formulated.
Yes. 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 So rescission
but
would...
then you were making a separate point that rescission would not have been available simply because the services had been performed.
Well,
were you?
Fraud.
That might be a matter of some legal debate as to whether it could be rescinded in circumstances where it's been executed. But potentially, yes, it could be rescinded, notwithstanding the provision of the services. I accept that. But the point is, it has been affirmed. It was affirmed through the reliance on the contract and the particulars of claim, and rescission isn't available. The second point on rescission is even if one accepts that prior to the service of the particulars of claim, rescission was still, of course, open to Brown Rudnick. Even if one accepts that starting point. And even if one assumes that claims in restitution are not covered, as to which query, I'll come back to that, but even if one makes that assumption, it would not matter. It is sufficient that the claim that has been brought, the claim for damages, is covered. And the principle on this point is that if a claim may be classified in a number of ways or brought under a number of causes of action, then there is coverage if any one of those classifications or causes of action is covered. And for that, I wish to take you to the court too, if I may, some authority that we found overnight. I did give my learned friends the copies of this early this morning. We've got copies for the court. If I could please hand them up.
Usher, I wonder if you could help.
What we've done is we've updated the index, and we provided 2 additional tabs, 4 and 5, for the report. And at tab 4, the court should have I'll give the court a moment to
If you would, thank you.
find a place for it. And at tab 4, the court has the extract from Colombo under the heading Relevance of a Claim Against the Assured, classifying the assured's liability at paragraph 2157. Liability policies typically cover liability arising out of a wrongful act, generally defined in terms of an act, error, or omission. Unless otherwise stated, the term wrongful act encompasses both intentional and unintentional acts, although in the former case only where there's no deliberate intention to cause harm. The problem raised by this form of wording is that the claim made against the assured may be framed in terms which take it outside the policy, although the actual substance of the claim is nevertheless insured. The key question is not how the claim is framed, but rather its actual substance. It was thus held in Westlake, Price and Ching, which the court has already seen extracts from, that a policy which covered only negligence did not extend to a mixed claim based partly upon negligence and partly upon fraud. And then this is the key sentence. Where, however, a claim against the assured may be classified in a number of ways, there is coverage if any one of those classifications is insured, and the proposition cited at footnote 49, which I think you've got over the page, I don't think I had, but it's the decision of Mr. Justice Potter, footnote 49 in Capelcure, Myers Management and McCarthy, which the court, I hope, is now at tab 5.
Yeah.
And the facts of this case, what will give me a moment, please? I'm just going to take my copy out of my bundle. The facts of this case were the plaintiffs were members of the London Stock Exchange, and they faced a claim by the trustees of the Mirror Group pension fund in relation to the alleged misuse of securities owned by the pension fund. various causes of action were advanced. Some insured, one insured, some uninsured. The causes of action were breach of contract, breach of fiduciary duty. Those were the uninsured claims. And also, this was the insured claim, breach of statutory duty under the Financial Services Act 1986. The claimants, or the plaintiffs, sought a declaration against the insurers that they were entitled to indemnity against the costs of the claim. Insurers argued, on the other hand, that they weren't because of the mixed nature of the claim, and that in substance it was a claim for breach of contract and fiduciary duty, not for breach of statutory duty. The insuring clause, if one goes to page 2 of the judgment of Mr. Justice Potter, is set out at the bottom of page 2. It's insuring clause 5, the relevant clause, and it related to breach of statutory duty. This is the last 2 lines on page 2 of the judgment, under the Financial Services Act. And then if one goes forward, please, to page 5. Page 5 of the report. The judge sets out at the second hole punch the argument of Mr. Brindle, who was acting for the insurers, who relied on the West Wake, Price and Ching case. And could I invite the court to read how the argument was put from the paragraph beginning, however, in this argument. Over the page. When you get over the page, the judge summarises the decision of Mr. Justice Devlin and Westwake. The key paragraph for our purposes is in the middle of the page, where the argument of Mr. Brindle is summarised in the paragraph beginning in relying on the case of Ching. If you could please read that paragraph. And then the judge dealt with the argument in the next paragraph, where he said, I do not consider Mr. Brindle can derive assistance from Ching in relation to the facts of this case. There is an immediate and obvious distinction for the position in Ching, where 2 separate and distinct events, or acts of default, were relied on, namely the theft by the servant and the separate failure by others to prevent or detect such a theft, one of which was within the terms of the policy and the other not. In this case, there is only one event relied on, misdelivery of the securities, which event in itself gives rise to a variety of causes of action. Pausing there, in our case, of course, there is only one event, or one series of events, the misrepresentation. And then the judge continues to distinguish the position from that considered in Ching over the page, at page 7 of the report. Paragraph beginning, on the other hand, the top of page 7, it seems to me that loss by a combination of causes must be distinguished from a loss by a single cause, which can nevertheless be properly described as amounting to a number of perils or giving rise to a number of causes of action, one of which may be outside the terms of the policy, but one of which is plainly within its terms. In such a case, it seems clear to me that the assured is entitled to indemnity. The cases to which I've referred are, of course, cases of marine insurance or insurance against perils, whereas the case before me is one of liability insurance, in which the single act or omission giving rise to the claim is capable of being characterised as a breach of more than one duty owed to the claimant as third party, while the insuring clause relied on relates only to one class of liability. However, it seems to be similar principles apply. Accordingly, it seems to me that if on the facts as pleaded by the mirror action, which are not disputed for the purposes of this hearing, an action by MGNPT lies against the plaintiffs, which is properly framed in a form in which it would be a necessary averment by the plaintiffs, that the plaintiffs are, by virtue of their status and or activities, under various statutory duties of the plaintiffs, which on the facts they have breached, and if an action could successfully be brought against them in that form, it's irrelevant that a different cause of action, such as breach of contract or breach of fiduciary duty, could also be successfully alleged against them on the same facts. We say that reasoning applies here. We have a single set of facts which are alleged to give rise to the liability, namely the alleged misrepresentations of Mr. Coulter on behalf of the firm.
And then has some quite curious consequences, if Mr. Justice Potter is right. Suppose one were looking at the liability after it's been ascertained, and actually the action had only succeeded on the basis, in this case, of breach of contract or fiduciary duty, and had not succeeded on the basis of breach of statutory duty.
Well, then there'd be no cover would be one answer.
But would it? On this basis,
if liability has not been, if
No, I
the
suppose
loss
that's
has not
right.
been caused by an
I suppose
insured
that's
risk, but there's no cover.
Yeah. I mean, he frames it as action could successfully be
Yes.
brought.
yes, sorry.
So here we have a single set of causes of the liability that's established, which is the misrepresentations. Those misrepresentations can be framed either as causes of action for damages, if Brown Rudnick have done, that is covered, or, assuming rescission was available, a cause of action which included rescission. And if it is a big if, but if restitution isn't covered, then it doesn't matter on this authority. So we say, therefore, that the question of whether, if you accept my argument thus far in relation to restitution, the question of whether restitution or claimant restitution would have been covered by the policy had it been put in that way by Brown Rudnick, that doesn't actually arise the decision, but I do have submissions to make on it if you disagree with the analysis thus far in relation to submission. Because we say the premise of this part of the insured's argument is wrong. We deal with this point in paragraph 49 of our skeleton. We submit that the policy does indeed cover claims for restitution. The judge, of course, disagreed with us on this point at paragraph 113. And we make 3 points to support this proposition. The first is very straightforward. According to the natural...
Sorry, just before you launch on those, when you say the judge disagreed on that, he seems to have disagreed, doesn't he, on the hypothesis that what one is dealing with are claims to which there is no
Yes.
contractual entitlement.
Yes, yes. Yes. I may have read what he said more broadly, but perhaps we should go back to what he did say. Taken it to be wrapped up in a wider point that claims and restitution would not be covered.
Well, it's all
Well,
under
yeah, that may be right. It's under the heading,
Yes.
isn't it?
Yes.
claims to recover amounts paid
Which never became due.
Yeah.
And then there's the reference to the
Yeah.
US authority and so on. And then he deals with it not really as a question of
Yeah.
the principle of indemnity, but on the language of the
It's actually
cover.
It's actually quite clear because the first sentence, what are the position with the solicitor
Yes.
receives account some money to which it had no contractual right.
Yes.
And he retires to that in the middle of 113.
Yeah.
Yes.
So he doesn't seem to have addressed the position. What would happen if if the solicitor did have a contractual right and the claim was owed in restitution?
Although his reasoning at 111 and 112 is about the policy language,
Yeah.
and although there is the wide wording, as he recognises, in the insuring clause, he goes to the self-insured element and refers to the minimum terms under the English regulatory position.
Yes. I mean, if one, if one goes to 110, the reason I'd read the judge as having not only the specific point about the recovery of sums under contract in mind, but the more general sort of restitution-based claims, a category which is not necessarily precisely defined, is at the beginning of 110, where he says in the second line, the question of whether and if so in what circumstances an insured can obtain indemnity under a policy in respect to the insured's liability to restore sums paid to by third parties is a complex one, which has been the subject of case law. And then he cites the American jurisprudence, which is not necessarily limited to the contractual situation, in an article entitled "The Insurability of Claims for Restitution." But I entirely accept your lordship's point. The judge is not squarely rejecting the proposition that this policy does not cover. He's not clearly saying that this policy does not cover any restitution-based claims at all.
Well, I'm not sure. I think I would read it as him saying that is the construction of this policy as a matter of construction.
Yes.
But what he's not saying is that the indemnity principle prevents claims in restitution.
Yes. And I would accept that. What I'm seeking to address is my learned friend's case, as I understand it, that this particular policy does not cover a claim in restitution. And I say it does, for three reasons. One, according to the natural and ordinary meaning of civil liability in Insuring Clause 1, a restitution-based liability is a civil liability. And there is no exclusion for restitution-based claims. On the contrary, 2, this conclusion is reinforced by Exclusion Clause 16, which we saw yesterday in relation to bank failure. That exclusion recognises, implicitly at least, that a restitution-based claim to restore client account monies or to repay client account monies would otherwise be covered. And 3, the commercial and regulatory context again support the view that restitution-based claims are covered by the policy. In paragraph 49 of our skeleton, page
Sorry, I'm just making a note. Give me that point again.
Yes, the commercial and regulatory context. support the view that restitutionary claims are covered by the policy. And in paragraph 49 of our skeleton, page 148, we give two examples to test the point. The first, paragraph 49A, client pays the firm's fee of £1,000 before any services have been provided. Partner absconds with the fee. Client brings a claim in restitution against the innocent partners for return of the fee on the grounds of a failure of consideration. The insured partners have not received any part of the fee. I say the claim is fully covered. If it weren't fully covered, it would be a major gap in the policy.
Classic example of
feeling of
what PII cover is intended to
exactly
cover.
And in relation to the next policy, my learned friend sent me something of a challenge because he suggested that this shows how extreme our case is, but it's not extreme at all, I would respectfully say. The example is that an insured is liable to pay £1,000 on a judgment against the firm for unjust enrichment, say, or let's say upon an assessment, discounting or reducing fees under the Solicitors Act, of which only £100 has been distributed to the insured. So he's liability of 1,000. He's received a benefit of 100. We submit the balance of £900, which he hasn't seen, would be an insured loss, requiring the insured to bring into account the full 1,000. Circumstances where 900 have been lost to the insured because he's never seen it, would fail to give effect to the indemnity principle. The other example I would give, perhaps closer to this case, is rescission itself. Let's suppose a case where a client has paid a substantial fee up front to the firm, pursuant to the contract, which has been agreed, discovers at the outset that there's been a misrepresentation. Well, no, let's assume he doesn't discover at the outset. He discovers in due course that there's been a misrepresentation and seeks to rescind. All of the partners will be jointly and severally liable to return the fee in the full amount to the client. And you may have a partner who, again, has to shoulder the entire liability because his partners or her partners aren't good for any contribution. We submit that situation would again be covered by the policy. If it's not...
I understand you're making the point by reference to the composite nature of the policy and the position of the individual partners. But are you drawing any distinction in that example between whether the fee has been earned or not earned? Does the example assume it's not been earned?
The example is good whether the fee has been earned or not earned. If the fee hasn't been earned, but the individual insured solicitor has not benefited from it,
and that I understand.
It's still a loss.
And I understand. What I'm feeling my way towards is whether there's a separate argument, which doesn't depend on the individual partner's position, where the fee has been earned, based on the points you were making earlier about the expenditure of the firm's time, goodwill, overheads, and so on in earning the fee.
Well, not that I can see, because the case advanced against me is restitution-based claims that are excluded. They're outside the scope of cover. And so if that's right, then one doesn't even get to the question of loss. Although I would say there is a loss, but my learned friend's argument is that restitution-based claims are simply out with, as I understand it, the insuring clause. But if they're within the insuring clause, and one gets to the question of loss, then yes, if services have been provided, I would make the point your lordship's just raised, which is...
Well, you're giving examples of how it would be odd if they were outside the scope of the insuring clause. And if one example is where a loss has been suffered because the fee has been earned, and a restitutionary claim is brought,
then that's another example. I suppose I was testing it with an even more perhaps sympathetic example where 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 the partner simply hasn't seen the fee at all.
Yes.
They all come back to the same conclusion, I submit. So that's the third point, the regulatory and commercial context. The fourth point is that the case law does not support any general proposition that claims and restitution are not covered by a professional indemnity policy. The authorities are rather slight on the point, but at paragraph 53 of their skeleton argument, the insurers cite a passage from the 13th edition of Colombo, and can I take you back to that, please? It's in Bundle 2, tab 38 of the authorities. Page 1135. Where it said that at paragraph 1130 under the heading restitutionary claims, a liability policy will not cover restitutionary claims. The essence of such a claim is that the insured is in possession of money which did not belong to him. Pausing there, I emphasise, my ladies and my lord, the reference to the insured being in possession of money. Of course, if the insured's in possession of money in the examples I've given a moment ago, then that must be brought into account when quantifying the loss. If it were a fee to which the insured wasn't otherwise entitled, no service has been provided, the fee hasn't been earned. That would go to the question of loss. But of course, the insured, if you're talking about a partnership, may not be in possession of money. He may not have seen any of the money, or may have seen only part of it in the examples that I gave a few minutes ago. And then the passage continues. Accordingly, a restitutionary claim is inconsistent with the notion that the insured has suffered any loss. Again, that is a proposition we respectfully say, in terms of its generality, does not hold true in all cases. I've given you examples a moment ago where, despite the restitutionary nature of the claim, the insured will have suffered a loss. And then you've got the last line about professional fees not being covered by the policy. Now, the advance, it has to be said tentatively, the authorities relied upon are those in 54, which I can deal with fairly compendiously, but they are 4. But before going through those, we've also looked at McGillivray, which makes essentially the same point with even more economy, and cites only the AXA insurance case. We haven't brought McGillivray along. All of these cases cited in paragraph 54, with the exception of Stone and Rolls, which is not an insurance case at all, but all of the insurance cases say that if you have an insurance clause or an insuring clause that's limited to claims for compensation and damages, then that language in the insurance clause is not apt to include a claim in restitution. Insurance against claims for damages and compensation is not apt to cover claim in restitution. But that, of course, depends upon the particular wording of the policy, and all of those cases were decided upon the wording of the policy. And those decisions simply reflect the undoubted fact that restitution or a claim of restitution is not a claim for damages or compensation. We dealt with these cases very briefly in footnote 4 of our skeleton, but if I could just deal with them insofar as necessary orally, starting with Stone and Rolls and Moore Stevens, which the judge referred to below at paragraph 103, Roman 2 of his judgment. You have it in tab Authorities Bundle 1, tab 20. This case will be known to your lordships. It's not an insurance case. It concerned whether the defence of ex turpi causa was available to a company's auditors who were being sued by the liquidators for failing to detect and prevent the dishonest activities of a person who was the directing mind and will of a one-person company. And the particular passage that the editors of Colombo appear to have in mind, although I don't think they cite any paragraph of the report, is paragraph 5 of Lord Phillips' judgment. Pick it up at page 389, please, of the report. Where he said at the bottom of the page, paragraph 5, page 389, my initial reaction to the S&R's claim was that as a matter of common sense, it could not succeed. There were three reasons for this reaction. The first was that S&R are seeking to put themselves forward as the victims of fraud when they were in fact the perpetrators of fraud. The true victims of the fraud were the banks. True it is that S&R are now subject to a paper liability to the bank of over £94 million, but common sense would suggest that this is not really a loss that they've suffered. They started with nothing, and their alleged losses are sums that they acquired by fraud and then paid away as part of the same fraudulent transaction. If a person starts with nothing and never legitimately acquires anything, he cannot realistically be said to have suffered any loss. And then he cites the judgment of Lord Justice Mummery in the Court of Appeal. Does common sense matter? Yes. It's contrary to all common sense to uphold a claim that would confer direct or indirect benefits on the corporate vehicle which was used to commit the fraud and was not the victim of it and the fraudulent driver of the fraudulent vehicle. He then deals with two other points of common sense which need not concern us. But his observation should be read in the context of what he said at the bottom of the page. If your lordships would please read from between G and H and the reference to Lord Hoffman's lecture on common sense and cause and loss. We say those observations have no parallel in this case. That case was not about a civil liability to pay damages in respect of fees that were contractually due for the supply of professional services. They're about a fraudster who is seeking to mount a claim in respect of the negligent failure to discover the fraudster's fraud. The next case relied upon by the editors of Colombo, and the only one cited, as I said, in McGillivray, is the AXA insurance case at tab 22. This case, volume 1, tab 22. The judge, I should tell you, you'll recall, referred to this at paragraph 103, Roman 1 of his judgment, judge below. This case concerned a public liability and contractors all risks policy with materially different wording from our policy. It referred to liability for injury or damage, and it was set obviously in a different commercial context, and it didn't have the regulatory context that we have here. We say the decision of His Honour Judge Simon Brown QC turned on the construction of the policy. That's clear from the passages I'll take you to. The insurers in this case sought a declaration that they were not liable to indemnify the insured in respect of various claims relating to the insured's involvement in the design, supply and installation of residences, a large residential complex. And if you court would go please to page 514, paragraph 12, you see a summary of the nature of the claims brought against the insured in the relevant Irish proceedings. Paragraph 12, in the Irish proceedings it's been alleged that Thermonex, that's the insured, owed duties and contract and tort to Jim were the main contractor, in relation to the design, supply and installation of the basements at the development, but that negligently and in breach of contract the relevant designs were flawed and the workmanship was defective, such that some of the basements leaked and had to be repaired. The claims are also advanced as claims for breach of warranty and negligent misrepresentation and in restitution. As the judge below noted in his judgment, it wasn't apparent from this case quite what the basis of restitution alleged was. And then if we go to paragraph 20, please, across the page 515, the next page I should say, you see the submission of the insurers at paragraph 20. AXA submits that any liability which Thermonex might have in respect of restitutionary relief is not a legal liability for damages, and AXA has no liability to indemnify Thermonex in respect thereof. And then
He describes it as a coverage issue in para 22.
yes,
Rather makes your point for you.
yes, and the policy terms where one sees the way that the coverage was framed. One sees at page 518. Well, 519, one sees an indemnity by the first hole punch on 519. The indemnity relates to liability to pay damages and expenses in respect of accidental injury to any person, loss or damage of material property. And there was a similarly worded indemnity in another section of the policy, which you have in the adjacent column under the heading Contractors All Risk section. And then one sees, as my Lady Justice Andrews has already anticipated, at paragraph 66, he deals with the point as a matter of coverage, construing the policy rather than as a point of general principle. This is page 523 under the heading Restitutionary Claims, and I'd like the court to read paragraph 66. No, my learned friend may seek to read that as a general statement of principle, but I submit it can only be read as in the context of the particular terms, and the judge refers to compensating a claimant for its loss, and the language of the policy referred to compensation.
It would be an easier submission to make, Mr. Coleman, if it weren't for the reference to Goff and Jones.
Well, the reference to Goff and Jones is, we'll check it, but I anticipate it's a reference to the general proposition that that restitution is about reversal of gains. In fact, I think we do have that, I think, in the authority. But Goff and Jones has not addressed the question of whether a claim in restitution can be, in principle, an assured claim under a liability policy. And with respect to the judge who decided this case, it could only have been disposed of on the basis of the particular terms in question, which referred to compensation and damages. If he was stating a more general point of wider application that in principle restitution-based claims can't be insured under a liability policy, I would respectfully submit that he's wrong on that point. But my primary submission is that's not how it's to be read. The next case relied upon by Colombo is, I submit, was disposed of on very much the same grounds, based on the terms of the policies. At tab 25, it's the decision of the Supreme Court of Victoria in Australia, decision of the Court of Appeal. Sorry, it's the Court of Appeal of the Supreme Court, I think. Anyway, you have it at paragraph 20, tab 25. The insured in this case sought an indemnity against costs, or the costs, of defending proceedings brought by the Australian Securities and Investment Commission in respect of an alleged unregistered investment management scheme. The proceedings were discontinued. The claimant in this case, who'd been the defendant in the regulatory proceedings, then sought to recover his costs of defending the proceedings from the insurer. The insuring clause, if we turn over to page 636, contained an indemnity against, quote, loss arising from any claim in respect of a civil liability or a breach of duty owed in a professional capacity. So the focus was breach of duty, and that wording was significant to the reasoning of the court, as we'll see. And then loss was defined at paragraph 4 in terms of the aggregate of all amounts payable by the insured as civil compensation or civil damages in respect to the claim. And then at paragraph 6 over the page, claim was defined as a written demand or assertion of a right to civil compensation or civil damages. And one of the issues in the case was whether the claim that had been brought by the regulator against the insured was a claim for civil compensation or civil damages. And the court held that at most a claim for restitution might have been brought within the proceedings if they had not been discontinued, but not a claim for damages or compensation, and that a claim in debt or restitution would not have been covered. And the key reasoning is at paragraphs 51 and 52 at page 655 of the bundle. At paragraph 51, the court referred to another of its decisions, I think, Cantfield, and stated that Cantfield is authority for the proposition that a claim for civil damages or civil compensation does not include a claim in debt. Like reasoning points equally strongly to the conclusion that nor does such a claim encompass a claim for restitution or a civil penalty. Still less does it include a claim for the relief sought by the regulator. And then I'd invite the court to read paragraph 52, please. So again, this is another case founded not upon any general principle that restitution-based claims can't be covered under a policy, but rather upon the particular wording of this policy. And the same goes for the last of the cases, which you have, if we can close that bundle please, tab 33. Again, another Australian case. This time it's a decision of the Federal Court of Australia. And the relevant issue in this case was whether a vendor's claim in respect of commission wrongfully taken by the vendor's agent fell within the particular wording of the insuring clause. And the insuring clause can be found at page 950. And it was again expressed in terms that ruled out a claim for based on decision. And perhaps if the court would simply read to itself the insuring clause at page 950, clause 1 under civil liability, and there was a similarly worded clause under trade practices at point 2. And at page 954, paragraph 189, the court summarised the principal claims. The first 3 claims are for breaches of the Australian consumer law, that's the ACL, and for breach of fiduciary duty. The loss and damage that APD claims to have suffered as a consequence of each of these breaches is pleaded in paragraph 41 to be $12,672,000. And then at paragraph 190 we have the key reasoning. None of these claims is for debt or restitution or for the performance of the contract. So the court decided that these claims were covered. And if you could please read or note paragraph 90, I'd be grateful. All one gets from these authorities, I submit, is that the question whether a claim for restitution is within the scope of cover depends upon the proper construction of the particular terms of the policy. We are concerned with very different terms. Finally, on the restitution point, as long ago as 1957, Mr. Justice Devlin recognised in the West Wake and Chin case that in principle, subject to the wording of the policy, restitutionary claims could be within the scope of cover. Now, what he said was very tentative, but it is worth noting that a judge as experienced in this field as long ago as 80 years ago didn't see there to be anything intuitively or inherently unlikely in such a proposition. One sees that if one goes to, please, to Authorities Bundle, tab 10. You'll recall that the issue in this case was whether a claim, mixed claim and fraud or negligence was covered by the particular terms of the policy. And one of the causes of action in respect of the money that had been stolen by the employee was for money had and received. And at page 157, first hole punch, the judge said at the sentence beginning, "I wish," halfway along the line, adjacent to the first hole, second hole punch, down the page, I beg your pardon. Second hole punch, halfway along the line. "I wish, however, to guard against the decision that all claims for money had and received are necessarily outside an indemnity policy in the terms of the present one, or that the authorities by which I'm bound would compel me to so decide. It might be, do not have to decide it, that a failure to account, which is due to a payment made to a third party, who was in good faith believed to be entitled to it, would be an error within the meaning of the policy." We can put the authorities away. So those are my submissions on restitution.
What do you say about the judge's reliance on the wording of the self-insured amount provision? Should we just have that out in front of us?
Yes. If we
Call 15,
yes.
page 198.
Yes, what I say in relation to that is that the dominant clause, the governing clause, is the insuring clause. It's page 198. The insuring clause is not limited to claims for damages and not limited to claims and damages. It may be that the draftsman nodded at paragraph 13, so to speak, but paragraph 13 cannot drive, I submit, the proper interpretation of the insuring clause in circumstances where, firstly, the ordinary wording of the insurance clause covers a claim for restitution, and secondly, as I've sought to persuade the court, there are compelling commercial and regulatory reasons why the insuring clause would include within its scope a claim for restitution. And given the weight of those considerations, both the language of the insuring clause and the commercial, and I emphasise regulatory considerations, the most important point of all, it would be very much the tail wagging the dog if the wording of the self-insured amount were in some way to limit what is otherwise the natural meaning supported by the context, regulatory and commercial, of Insurance Clause 1.
Is one possibility that the concept of self-insured amount doesn't apply to every type of claim under the policy?
Well, possibly. I mean, I've accepted in the examples I've given that, for example, if the firm receives a fee for £1,000, to which the firm simply isn't entitled, no service has been provided and the contract's been rescinded, the individual insured partner receives only 100 of the 1,000, but doesn't see the other 900. I've accepted that he'd effectively be self-insured for the 100 he's had the benefit of, but he'd have an indemnity for the 900. But whether that thinking it reflects what
it may be difficult when you look at the way the categories of claim are set out. I mean, fraud and dishonesty, for example, would be slightly odd if you had a deductible for damages claims, but not for restitution claims.
Yes, and anyway, you have my submissions on that point. That then brings me to the second of the general assertions, which generated some discussion yesterday, which I want to address. And that, just to remind the court, is the insurer's contention that since the policy does not insure unpaid fees, it does not indemnify loss caused by liability arising from fees that were in fact paid. And that point is made at paragraphs 43 to 50 of my learned friend Skeleton, and I think was also advanced yesterday. We've responded to it in paragraphs 56 to 58 of our Skeleton. But with respect, this argument involves a non sequitur. it is correct that the policy does not insure unpaid fees. That is because it is professional liability insurance, not credit risk insurance. And credit risk and civil liability risks are different risks, both from a commercial perspective and a regulatory perspective. From the solicitor's commercial perspective, he or she can control credit risk. They can try to get fees in on account, they can agree stringent payment fees, terms, and monitor age debt and so on. If those self-help measures are not acceptable, the solicitor can go out and buy credit risk insurance if it's available on the market. On the other hand, the risk of a civil liability in respect of fees that have been paid to the firm, which may not emerge till some years later, cannot be controlled, of course, by getting fees in on account and so on. That risk can only be controlled by insurance. So the credit risk and the civil liability risk are materially different in nature from the solicitor's point of view. But they are also materially different from a regulatory perspective. Because the public interest that solicitors should be insured against civil liability, including civil liability in relation to fees, see Swade and the Law Society and the judgment of Sir John Linelot, is simply not engaged if the client has not paid his bill or her bill. Now, we submit that the insurers are in fact wrong to suggest that the cover provided by the policy depends upon the fortuity of whether the client has paid the fee or not. Paragraph 57, we give the example of a solicitor who acts for a client in a claim which is struck out. The solicitor sues. This is all set out in paragraph 57. It may be easier just to take it from 57 if the court would go back to our skeleton, page 151, and grateful if the court would remind itself of what we said at paragraph 57. Now, there was an interesting discussion yesterday about what would have been the position if Tughans had sued for the fee before it was paid and the impact of equitable set-off. My fundamental point on that is it doesn't matter, even if my load of friends write about that we couldn't have sued for the fee, it doesn't matter, the reasons I'll come on to. But just on whether my learned friend was right, we do not accept that Tughans could not have sued for the fee because equitable set-off would not have extinguished the legal right. The fee would have still been due and the claim for damages would have been covered by the policy. All that the equitable set-off would have done would have been to produce a net balance in favour of one party or the other. But the legal right to the fee would have remained. And our understanding of the position would be that in this scenario, Bruins would include as part of its claim against the firm its as yet unmet liability. in respect of the fee.
But when the liability was thereby ascertained by applying that equitable set-off, there would be no liability to the extent of the fee.
Well, I can see the argument. There may well be a counter argument that, as with the case of negligence, the liability, notwithstanding the set-off, would nonetheless be an insured liability met by the policy. But I don't want to get ensnared on that point, because my fundamental point is it doesn't matter. Even if the insurers are right, the argument takes them nowhere, because if they're right that we couldn't have recovered the fee, that would simply reflect the fact that this is liability insurance, not credit risk insurance, and that the insured peril is only engaged if there is a claim against the firm for the fee. Insurance, as you know, is concerned with risks that are inherent in the natural world and in human affairs, and it's the nature of insurance that those risks may have an arbitrary and random nature. A ship sinks in the Atlantic. According to chance, it could have been hit by a torpedo or overcome by a superwave. One risk may be covered, the other not. The building is destroyed by a storm. According to chance, it might be destroyed as a result of an insured peril, or it might be destroyed as a result of an uninsured peril. An employee damages the company's interests. According to chance, it may be through negligence, if so covered, or dishonesty, if so not. And most recently, the coronavirus test case that went to the Supreme Court, Financial Conduct Authority, and Arch is an illustration of a case where the somewhat random nature in which a pandemic developed impacted on the insuring clauses. It all depends upon the scope of the policy and whether an insured peril is engaged or not. And in this case, the parties have agreed, with the approval of the regulator, that the insured peril is civil liability. That's a paraphrase for the more extensive wording in Insurance Clause 1. And if that means that the firm has protection in respect of fees if they've been paid, because there's a civil liability, but not if they have not been paid, because they can't sue for them, then so be it. The scope of the risk is no doubt reflected in the premium. Well, that is our primary case. I now turn to our third headline submission, which I can take relatively shortly. If the court were to hold that the success fee is in principle relevant to the quantification of loss, then we submit that each respondent's liability to pay damages to Brown Rudnick in respect of the success fee would be an insured loss, save to the extent that as a matter of substance, the respondent's loss was offset by any receipt of the share of the fee. And I'm going to take you to the respondent's notice in a moment. This is paragraph 68 of our skeleton argument. Now, if you get to this part of the analysis, you've accepted the insurer's case that a fee earned under a contract induced by misrepresentation, or the payment for which was induced by misrepresentation, can be in principle treated as a gain to be brought into account in quantifying the insured's loss. And under this alternative case, we say if you get to that point of the analysis, then it should only be brought into account if, as a matter of substance and reality, it reduces or extinguishes the loss caused by the insured liability. I do emphasise that this is very much a fallback position and should not be seen as derogating in any way from our primary case. which is that as a matter of principle and having regard to the proper meaning and effect of the policy, there is no gain to be brought into account, regardless of whether my clients have received any benefit from it. And you haven't yet, in the course of the hearing, been taken to the respondent's notice, I don't think, which you've got at tab 9, page 125. Can I ask the court, please, to read the text from the second paragraph beginning the judge's order? Should be upheld for the further alternative reason. Then this, just to remind you, is what's been called the qualified claim, which was pleaded. You saw yesterday paragraphs 112 and 113 of the particulars of claim. And there is a corresponding prayer for relief matching at paragraph 133 Roman 4 of the particulars of claim in the arbitration, the reference for which is supplemental bundle tab 11. Page 87. I don't think we need to turn it up. And we submit that the extent to which the fee diminished the loss would fall to be considered separately for each respondent. It would depend on whether or not the balance of 4 million odd held in the office account is released to the respondents, and if so, the amount of each respondent's share under the partnership agreement. For example, the respondent, who we've mentioned in paragraph 11C of our skeleton argument, would bring into account on this argument £233,000 if that sum were ever released to him after the criminal proceedings. As I mentioned yesterday, this is precisely what the respondents have offered to do in its open offer of settlement. Which I would like to take you to, because you'll see how this might operate in practice.
I understand your point about release from the undertakings.
Yes.
But does it then, suppose they are released, does it matter as to whether it's actually distributed? Or is the question simply one of unqualified beneficial entitlement? You've put the argument in terms of receipt,
yes,
of a particular fund.
Yes.
But if a particular respondent receives an equivalent benefit because of its beneficial interest,
yes,
that ought to be taken into account on
yes,
this alternative argument.
Yes. Because the question is whether, in substance and reality, that any amount of the fee has extinguished or reduced the loss. So yes, that would be the question. And I mean, if we go to the open offer, please, this approach reflects what we've already offered to do, or my clients have, at special bundle tab, supplemental bundle tab 22. The letter of the 23rd of May of last year. And under the heading of open offer and full and final settlement of the proceedings, this was a couple of months before the hearing before the judge. It was noted in paragraph 3 that my client's priority as regards the success fee element of the damages claim has always been to obtain the insurer's agreement to indemnify the relevant partners only to the extent that the proceeds of the success fee are not available to meet any liability in respect to the fee. Paragraph 4, our clients are prepared to compromise your client's arbitration claim on the basis that they would waive their rights to full indemnity in respect of the claims, in respect of the success fee. Insofar as that fee or part thereof becomes available to them, that is to say, A, insofar as they're entitled to and succeed in recovering part or all of the sums of 1.5 million and 3.5 million odd paid as tax and income tax to HMRC, and B, insofar as the sum of £4 million odd or part thereof becomes available to the firm and its partners. And then an example was given in paragraph 5 as to how that would work. And then paragraph 7, our client's waiver would be made on the basis that when their liability to Brown Rudnick in respect of the success fee has been ascertained in due course, the insurers would not delay any payment due under the indemnity on the account of any unresolved issues concerning Tughans' ability to recover any element of the proceeds of the fee. In the event that the insurers in due course indemnify our clients in respect of the claim, in respect of the success fee, and our clients subsequently make recoveries in respect of tax, monies and office account, those monies would be paid to the insurers. And then at 8, our clients intend to take reasonable steps at the appropriate time to exercise such rights, if any, that they may have to obtain the release of the monies and office account, and also to recover tax.
So does this contain the limitation to the individual respondents' share?
Well, it was
Doesn't look as
intended,
though paragraph
whether
5
it's
does.
expressed.
Sorry, it doesn't look as though paragraph 5 does.
Well, this letter's, I think, glossed over that detail, but I think the intention behind paragraph 5 would be to...
In monetary terms, it's not a small detail for your clients.
Well, no, but I think the intention of the letter was, in substance, to reflect what I've sought to outline. But whether or not the letter correctly hit the target, I respectfully say it doesn't really matter at this stage. The intention was to encapsulate something which is now in the respondent's notice, and is the alternative case, which was also advanced before the judge. Now, we submit that this approach, if you decide against us in principle, that there may be a gain to take into account, this approach would accord with the general approach that issues of causation and loss are resolved in a pragmatic, common sense way by reference to the substance of the matter, the point we make at paragraph 68b. And this proposition, at least, appears to be common ground, listening to what my learned friend said yesterday. At paragraph 60, paragraph 68b, we've cited some authority. Two of the cases concern causation, and we don't need to turn them up. They just advance the obvious proposition that when one's looking at legal causation and proximate causes and multiple causes and so on, one can have regard to common sense. More on point is the third authority we cite, which is British and Foreign Insurance & Co. and Wilson Shipping, which illustrates the approach in an insurance context. And if we could turn that up, please, at volume 1, tab 8 of the authorities. And this, we submit, illustrates that the question of loss is approaches a matter of substance and reality. The facts were that a ship was damaged by one risk covered by the policy, but not destroyed, damaged, during the currency of the policy, but before the damage had been repaired, she was lost as a result of a risk not covered by the policy. Held, the insurer was not liable for the unrepaired damage. And the approach of Lord Sumner in particular is helpful on this point. If one goes please to page 131 of the report. Said at the bottom of page 131, about 4 lines to the bottom, I do not see anything intrinsically in conflict with the contract of insurance in the proposition that perils insured against have not caused any direct loss, where although the ship was damaged, the owner had nothing to pay, and although the ship was depreciated, she ceased to exist as a ship before the time came for measuring the amount to be recovered from it. At the date, there was no pecuniary loss against which the owner could be indemnified. And then there's the discussion of the authority which the House follows, Livy and Jansen, in the next paragraph. And then in the middle of the page, Lord Sumner says this: the foundation of the rule in Livy and Jansen, of course, is that an insured cannot be allowed to recover under a contract of indemnity both a total loss which he has suffered and a partial loss which in substance he has not. And I emphasise the words in substance. So the question of loss is to be assessed as a matter of substance and reality, not form. Now the judge rejected a similar argument to the one I'm advancing under the respondent's notice, albeit in the context of an assumption that the payment wasn't due. If we could go back please to paragraph 114 of the judgment. (114) comes in the section headed Claims Against the Solicitor to Recover Amounts Paid Which Never Became Due. It's page 108 of the full bundle. And the judge said, well, perhaps I can invite the court to read what the judge said at 114, please.
Why the assumption is the exercise of good taste in relation to wines and not in relation to art. It may be, with respect to that, she misunderstood the point. It probably reflected the way I sought to explain it. But as we say in our skeleton, paragraph 68b, the judge wrongly understood that the argument proceeded on the basis that it was the payment away, or the commitment of the fee elsewhere, that generated the loss. We see that from the first sentence. And that puts my argument back to front. It's the claim in respect to civil liability, the insured peril, that prima facie causes the loss, not buying good or bad art or wine. That if, contrary to our primary case, the success fee is relevant to quantification, then the court is entitled to consider as a matter of substance whether the success fee has offset any part of that loss. Of course, if a partner spent the money on art or poor wine or invested in a South Sea bubble, then for the purposes of my argument, he or she's had the benefit of the money. My argument doesn't apply in the scenarios the judge has posited. And then as we explain in paragraph 68c, if the face of the money held an office account
remains unresolved when the respondent's right to be indemnified accrues in due course, if it does accrue, then in accordance with the usual principles of subrogation, my clients would have to account to the insurers in the event that their respective shares in the fee was subsequently released to them. Dealing briefly, if I may, with the insurer's objections to this argument, they have two. Firstly, they say that the payment of income tax and VAT was a voluntary action which could have been avoided by disclaiming the fee. That was the point made orally yesterday, but see also paragraph 69 of their supplemental skeleton argument at core bundle 4, page 56. This is a bad point because the judge and the arbitrator found that the fee was contractually due for professional services, and as my Lady Justice Falk observed yesterday, that there is no basis for thinking that VAT and tax are not due in relation to a fee that's been earned pursuant to the contract. Even if the insurers were right on that point, it would not avail them, because the question on this part of the case is the extent to which, for any given insured respondent, the basic loss, as measured by the amount of the liability, is offset by the success fee. And money that's been lawfully paid to HMRC will not offset the loss. And I think, as was picked up yesterday, the suggestion that my clients ought to have returned a fee in circumstances where they didn't know whether they're liable to return it or not, and that remains the position, is somewhat unrealistic. The second point made by the insurers is that the remaining proceeds of the success fee subject to the undertakings, they say, are not at risk of confiscation. And they even say that the National Crime Authority would be content for the money to be released to Brown Rudnick. Well, I'm conscious of the time. I think I can conclude in
I was
2
hoping you
minutes.
might say that.
If your lordship's happy for
Keep going.
yes. The second point they make is that they dispute whether the money in office account is at risk of confiscation, and they say that the National Crime Authority would be happy, they speculate, for it to be returned to Brown Rudnick. This is paragraphs 25 to 28 of their supplemental skeleton argument. We do not accept this for the reasons we've set out in paragraph 9 of our reply to this supplemental skeleton, which you have at CB 16, page 214. Clearly, the NCA considers that there may be a proper basis for confiscating the money, which is why it required Tughans to give the undertaking not to release it. My clients can only speculate as to what the NCA's thinking may be, but we've identified in paragraph 9A of our reply potential grounds on which the NCA may confiscate the money. Nor can we accept that it can be assumed that the NCA would be happy for the money to be returned to Brown Rudnick. That assumes that the NCA would view Brown Rudnick as the primary victim, as opposed, for example, to the National Asset Management Agency, NAMA. The NCA's view of Brown Rudnick's entitlement to the money or its involvement in the matter is simply not apparent from the evidence. As we submit in paragraph 9C of our reply, the reality is that it's simply not possible for this court to determine whether or not the money will be confiscated, nor should it. All that is known is that the NCA considers that it is proper grounds to require the undertakings to be given, even if the insurers were correct in their speculations about the risk of confiscation. That has no bearing on the point of principle raised by our respondent's notice, which is that, in our alternative case, each respondent is only required to bring into account so much of the success fee, if any, that is released to him or her in due course, or qualify that by reference to my Lord Justice Popplewell's point, in relation to which he can exercise a beneficial entitlement. So, my ladies and my lord, for all those reasons, I would invite you to dismiss the appeal. I should just mention your observations yesterday, my lord, about the form of relief if you were to be with the insurers. We entirely endorse what you said. It would have to be carefully crafted so as to be limited to the claims in misrepresentation. We did not understand why the insurers were so equivocal on that point yesterday. Plainly, the arguments raised before you, indeed the point of law presented to you, does not engage with the non-misrepresentation claims.
Those are your submissions, yes?
Yes.
Thank you. We'll resume at 2:05.
All right, if able.